Good evening, everybody. Welcome to the next installment of Constitutional Law. In this installment, we're going to be looking at judicial power. The learning objectives for today are to identify the origins of judicial review, discuss the supremacy of the Supreme Court, and understand that states cannot violate the Constitution. We discussed a variety of different assignments for last class. First, I wanted you to look at Article 3 of the Constitution, read Marbury versus Madison, read Martin versus Hunter's Leases, and Dickerson versus United States. We'll talk at the end about the homework, but there's not going to be any reading for the next lesson just because of the nature of the class. Where to start? When we start talking about Supreme Court decisions, most classes begin with Marbury versus Madison. It's almost cliche, but there's a very good reason for doing this, and that's because we do this because without judicial review, there frankly wouldn't be much constitutional law to worry about. Simply put, the information we are going to be studying exists because the court has made it exist. Without the court reviewing different things and issuing precedences, we wouldn't have anything to study. So a good place to start is to start by examining what happened in Marbury versus Madison. Where we are going to go. This week we look at how the Supreme Court declares powers for itself to conduct judicial review. But next week we're going to start looking at what limits the court puts on itself when it's reviewing things. Understanding that this is the boring part of constitutional law, right? This is not the glamorous part where we're going to talk about rights and liberties and how the police can't interrogate you without Mirandizing you and stuff. Well, we will talk about that a little bit. This is the fundamental stuff that establishes the backbone by which the Supreme Court is going to go about interacting with cases that exist. Before we get into that, I wanted to take just a minute and thank everybody who submitted an About Me section. I see a lot of you want to go to law school. By all means, it's a great career. I'd love to give you any pointers I can about that. I do want to note that I teach this class to try and prepare you. Having you read all these cases, this is the exact same sort of stuff you're going to be reading in law school. And they're the exact same cases that have been read for generations. If you've ever heard of the movie The Paper Chase, which let me find the year for you really fast. The Paper Chase came out in 1973, and the very first scene they say, all right, who can give me the facts of Parson versus Post? The very first class I had in law school, the professor said, who can give me the facts of Parson v. Post? There are some things that are so fundamental to the concepts in law school that you're going to see them over and over again. And we've approached how we study the law for the same for generations as well. And that's using the Socratic method and reading and briefing cases. When I have you brief cases, that's really for you to start practicing doing this, because we, unfortunately, in a class like this, are going to have a difficult time employing the Socratic method. That said, at least we can have you engage with the content matter. So for all of those in the class that want to potentially go to law school, treat this as a great opportunity to prepare yourselves. Feel free to ask me any questions. I'd be happy to answer them. So without any further ado, let's hop into Article 3 really fast. We'll go over that to start with, and I'm going to do that view so you guys can see the whole thing. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office. There's a couple of things to unpack here. And the first thing I want you to take a look at is the Supreme Court's established directly, but the rest of the judicial system is left up to the discretion of Congress. However, so that Congress can't try and, control the courts by changing how much money they pay them and stuff, they can't decrease the salary of judges. They also can't simply be like, you're out, we're no longer having you. Once you become a federal judge, you are a federal judge unless you are impeached or die, and they can't stop paying you. They could try and transfer you or try and limit your jurisdiction, but what good is it to have somebody that you're paying several $100,000 a year that doesn't actually do any work? So one of the checks and balances that's at play is to limit the way that you can change compensation. Think about it another way. If you don't like a particular judge and you're a congressman, the idea might cross your mind that no problem, we'll just stop paying this person, or we'll start paying this person like $1, and then we'll get somebody we want in there because this person will leave. Section 2. The judicial powers shall extend to all cases in law and equity arising under the Constitution, the laws of the United States, and treaties made or which shall be made under their authority, to all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof, and foreign states, citizens, or subjects. 2. In all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed, but when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. A couple of things to unpack here. First, there originally were two types of courts. There were law courts and equity courts. The law courts were the king's law, what was written in statute. Equity courts is what's fair. These were the ecclesiastic courts. In the United States, our federal system combined those right away. So we have courts of law and equity. In other courts, we have, in other states, we have courts that were separated and maybe have been combined later. But that's why that's there. It's an important note because we still have equity. It's just exercised by our law judges. The other thing is that the type of jurisdiction matters here. And we talk about original jurisdiction. That means the ability to hear the case for the first time or the ability to hear facts on that case. But when we get to the Supreme Court shall have, in all other cases, the Supreme Court has appellate jurisdiction, meaning that they get to review what's happened. We're going to skip Section 3. It's in here in the notes if you want to look at it, but it's not really relevant. So let's get to Marbury versus Madison. Marbury versus Madison happens at the transition between Adams and Jefferson. For those of you that are Hamilton fans or really good students of American history, you may remember that that was not a smooth transition. In effect, Jefferson, when he got elected, wanted to make a lot of changes. Adams, when he was no longer going to be president, did a lot of things to make things a little bit difficult. One of the things he did is he appointed a whole bunch of different positions that he could appoint. And the way the term fell, these appointments were going to go into effect because Congress wasn't sitting. Therefore, in order to make the appointment, all he had to do is sign the commission, and the Secretary of State would affix the seal of the United States and deliver it to the recipient. So on his way out, Adams issued several judicial commissions. These were executed by him, but did not take effect until actually delivered. Jefferson did not deliver them, or more specifically, Madison did not deliver them. He was the Secretary of State. Jefferson wished for them not to be delivered. People sued to try and compel their discovery, and this brings up some vocabulary that it's important you know. A writ, so you may have read in the case that they sought a writ of mandemus, and that sounds so cool. A writ of mandemus means a writing or a letter. Mandemus means to mandate. So when we transfer out of the Latin, it literally means that we are asking for a writing requiring that the Secretary of State deliver the commissions. Writs are what we call extraordinary. They are part of that equitable relief that's available from the, law and equity thing that we talked about a little bit ago. Because, as we'll see later, they're basically meant for, okay, this is right, we should do this, but we didn't think through and write a law related to it. This case is a little bit more difficult, and I should have probably primed you all for this, because I referred to this multiple times as issue, and I should have called it issues. However, Marbury versus Madison does a very good job of distinguishing between the fact that they are addressing three separate things. And they ask three questions. First, do the people here have a right to the commissions? And second, can they sue in court to enforce that right? And finally, does the Supreme Court have the authority to act in this case? The rules we're going to apply are the Constitution, specifically Article 3, to determine what the court's authority is, and various definitions from common law as expressed in treatises. A treatise is a legal document, usually written by a scholar, summarizing a large area of law. Back in the day, they didn't have a really good method for categorizing law or referencing it like we do today. You will learn all about it if you decide to go to law school. That is beyond the scope of the class. Legal libraries are a beast of their own creation. You will spend an entire semester learning how to use one. So we're not going to go into that method now. But before we had that method of organizing and categorizing law, what you would have is various individuals who would write big books summarizing all of the cases they could find in a particular area. So a treatise is just basically that. It's a book that summarizes all of it. So having discussed that, let's go down to application. For our first thing, for our first issue, do the people have a right to their commissions? The court reasons that the act of the president is a discretionary act. The president doesn't have to act, but the president does act. And when the president acts, that's the only discretionary act that exists here. The subsequent acts, such as affixing the seal and delivering the things, are simply ministerial acts. Often in the law, we're going to distinguish between discretionary acts and ministerial acts. But the big difference here is that a discretionary act, as the name suggests, is something that you have to make a choice to do. You don't have to do it, but you can do it. Whereas a ministerial act is something that you have to do by nature of your office. The Secretary of State, the court reasons, being an officer of the United States, must obey the law and carry out his ministerial duties. The law doesn't say he may affix his seal, or the seal of the United States. It says he shall. He doesn't have a choice. In this case, Madison, having received something fully executed and ready for the seal, does not have a choice. He is supposed to affix his seal and be done with it. Therefore, Marbury and the other situated individuals are entitled to receive their commissions. There's nothing that should break that cycle. So the second issue is, can these parties sue to enforce their rights? This gets into the information from common law. And what's reasoned is that where there's a right, there's a remedy. This is some of my favorite language in the law. It has been used for hundreds of years. And most recently, there was a case in Missouri that said that where there's a right, there's a remedy. The Supreme Court picked that up and cited Missouri law in reaching one of their conclusions recently. But basically what they're saying is that there's an absolutely absurd result if we say you have a right to something, but we don't give you the ability to do that. The court goes on to talk about if we had land grants, for example, where you need to pay for the land grant and then the grant is to be delivered, but you pay your money and the Secretary of State says, I'm not going to do that. What absurd results would happen if you bought stuff that weren't delivered? It seems akin to some of the fast food restaurants around here if you do Uber Eats or DoorDash. But so that's step one. Step two, where there is no other adequate remedy at law, mandamus is proper. So we talked about how a writ of mandamus is an extraordinary writ. And in order to get there, you have to be able to show that there is no other provision that would entitle you to the relief sought. Here there's not. They create the mechanism to carry out delivery of the delivery of the commissions, but nobody goes further and says what happens if you fail to deliver it, or can somebody get declaratory judgment, for example, that they are entitled to this. So because nothing exists under the law, mandamus is the proper remedy. But the court goes in a really weird direction next. When they ask the question of, can the Supreme Court actually hear this case? Can they go through with it? They say that the court has original jurisdiction over some things, but appellate jurisdiction over other things that aren't listed. And we saw that when we read through Article 3 just a moment ago. Mandamus is a power conferred to the court under an act of Congress. Specifically, there's an act of Congress saying that, yeah, okay, the court has original jurisdiction in these things, and we're going to expand that and say you also have original jurisdiction here. But the court reasons that this would render that appellate jurisdiction language superfluous in the Constitution. It says it doesn't make any sense that Congress would say this because this would mean that appellate jurisdiction stuff doesn't matter. And that can't happen. The Constitution is the law under which... it's not scrolling anymore. Okay. The Constitution is the law under which the Congress gets its power, and therefore they can't just go and supersede Congress. Because the Constitution cannot be superseded, and this law declaring that the Supreme Court has power to grant writs of mandamus is void. In declaring this, the court actually vests itself with some more power, though, because this isn't anywhere in the Constitution. If we switch back to Article 3, nowhere in any of this language does it say that the Supreme Court has the power to render laws unconstitutional, or to review legislation, or to even, frankly, interpret the Constitution. This is huge because everything that we have, all the derivatives of all the cases that we're going to review this semester are derivatives of this right that the court grants itself. They say that it is so important to the function of our country that we, the court, should have the ability to A, interpret the Constitution, and B, render laws that conflict with it void. So I have your post up for you all to go through, and I have a couple of questions related to this. So I'm going to take a minute to read the questions for discussion I've put up. Now remember, when you're doing, you do not have to confine yourself to the questions that I've posted. I do want each person to post at least one original idea, and you may post more. You may write derivative ideas, so responding to your peers' statements. One way or another, I need you to post a total of 3 posts. I'm sorry, a minimum of 3 posts. You can post as much as you want, but in order to get full credit, remember to post 3. The questions I've posted are, why do you think that the court took the trouble of finding that Marbury was entitled to his commission and that Madison should deliver it if they simply declared that they lack jurisdiction to hear the case in the first place? So take some time, think about that if you want to. The second question is, do you think it is okay that the court declared that they possess the power to interpret laws and to find them unconstitutional? And the final is, what do you think about the court holding that the feds can simply write laws that change state laws? And we'll see that in just a minute when we get to our second to last case for the day. Our next case, Martin v. Hunter's Lisi. This case deals with a state law and a federal treaty. And basically what happened was that they had during the Revolutionary War, the state declared, hey, listen, if you're a loyalist, if you're fighting against what we're fighting for, we reserve the right to void your land grant and take your land. However, a federal treaty decided that the proper owner of the land is the original owner. And so there's a conflict. The state says party B owns the land. The feds say the original owner, party A, owns the land. Hunter's party B. So Jude comes back, decides he wants his land back and tries to get it. And the state court says, nah, you can't have it. This is not your land anymore. The state law wins. The guy says, no, my land is my land. Here's this federal treaty that trumps you. And the state court said, nope, we don't have to follow that. And federal judges said, yeah, you have to follow that, and gave the land back to the original landowner. The Supreme Court takes the case and has to reconcile it. They have to say, okay, does the treaty control or does the state law control? And ultimately what they find is that the treaty does control. It's a federal law, and the supremacy clause is going to come into play here, and that state law is superseded by federal law. So state judges are going to be superseded by federal judges. The logic they employ is that federal judges represent the populace as a whole, where state judges represent just that state. I did not go through the trouble of briefing this completely, as this video is going to come out before you have turned your briefs in, and I want to give you all the benefit of getting to brief these as well without being tainted by what I've done. All right, the final case for today is Dickerson versus United States. This is a really new case, and perhaps we should have talked about this before, but when we look at citations, so let's scroll all the way to the front and look at the citation. We've got a couple of things that I probably should have told you before, but we're going to talk about it now. Marbury versus Madison is called the style of the case, and the style is always going to be italicized. Lowercase v period stands for versus. Most lawyers just read it as Marbury v Madison or Marbury versus Madison. Doesn't really matter. There are lots of formal rules for how you abbreviate things within there. You don't have to worry about those. I don't care about you getting citations right now. I do care about you being able to learn something from the citation. The second block of information behind this comma is the actual citation, where you can find the document. In this case, it's the 5th volume of the United States Reporter, page 137. The first number is always going to be the volume. The second number is going to be the reporter, and the third number is going to be the page number. Typically, in our cases, we're going to cite to the United States Reporter. The United States Reporter consists entirely of Supreme Court cases. Missouri, however, if we're talking about a Missouri case, that's going to be Southwest 2nd or Southwest 3rd, depending on how recent the case was. So it might be 25 SW3D 137. And that's just a different reporter. Next, we have the year. And in this block, it's always surrounded by parentheticals. And for example, with Marbury versus Madison, it says 1803. If we look at Court of Appeals cases, it's going to cite the court. In Missouri, for example, you'd see 8th period, CIR period, 8th Circuit. And then the year. But we don't put that when we're talking about the U.S. Reporter, because since all the cases in the U.S. Reporter are from the Supreme Court, we don't have to put that in there. Similarly, if we're talking about a state Supreme Court, we don't have to put like Mo, SP period, CT period, or anything like that. We can just put the state, MO. It's assumed that if you just put the state, it's the highest state in the place. Finally, we have the year. The year is always going to be in here. For example, 1803, Martin versus Hunters-Lacey is 1816, but Dickerson versus the United States is ridiculously new. It's 2000. I like newer cases because at this point we're not dealing with, while judges will always try and be wordy and everything, we're not dealing with brand new ideas for the most part. We are honing ideas, and therefore where we have a lot of vocabulary in Marbury versus Madison, a lot of reliance on treatises, in newer cases like Dickerson, it's a lot more established. We're going to look at a lot more cases that have already ruled a particular way. It's just going to be easier to read. For one, it's not 200 years old, but because they're trying to accomplish something different here. So Dickerson is a relatively new case. He was convicted of a crime and confessed. I believe it was bank robbery. The crime doesn't matter. He was not Mirandized before his confession. So when you're arrested, everybody has seen the cop shows, and you've seen where the police say you have the right to remain silent. Anything you can say can and will be used against you. You have the right to an attorney. If you cannot afford an attorney, one will be appointed to you. Do you understand these rights as I have read them to you? This is called Miranda. A lot of people think you have to Mirandize me if you're going to arrest me. Not true. Miranda has to be read when you are going to do a custodial interrogation. We'll talk more about that later in the semester when we get to the 4th and 5th Amendments. But what is important here is that there is this requirement before an interrogation occurs. It wasn't performed, and Dickerson confessed. However, after Miranda versus Arizona, the United States Congress decided that they don't want this law in the books. They don't want police to have to worry about Mirandizing people. So they passed a law in Title 18 that said if a confession is voluntary, then judges shall admit it as evidence. So the Court of Appeals held that the confession was voluntary and thus admissible under that law. When I should have said this before when I explained the law itself was expressly made to overrule Miranda. So what are the rules that are at play here? The rule we're going to apply here is the Supreme Court's power to interpret laws, as originally found in Marbury versus Madison. And here's the rationale. The court states that they are interpreting the Constitution and therefore promulgated a constitutional rule in Miranda. There's a lot of discussion about when we made a Miranda were we simply giving guidance, or were we saying that this is the way it should be? Relying on the language of the case, how the case has been applied subsequently, how other jurisdictions are applying the case. They say, yeah, we were absolutely declaring what the Constitution says. This is a constitutional rule. Because of all of this, the court holds that, yeah, it's a constitutional rule, and therefore the legislature can't simply pass a law to overrule it. Notably, if the legislature wanted to overrule it, they could have a constitutional amendment, but they can't simply say, we don't agree with what the Supreme Court says the Constitution says, and therefore we're going to pass a law to circumvent that. The Court of Appeals is overruled here, and the law is declared unconstitutional. What have we covered? We have talked about how the Supreme Court has granted to themselves the ability to review laws first, which is huge because it's nowhere in the Constitution. Second, we have talked about how the Supreme Court's interpretation is going to trump any lower court. The Supreme Court has declared itself to be better at interpreting laws than state courts. And then finally, we have seen that the Supreme Court is going to be a check and balance on the legislature. The legislature can't get around things that the Supreme Court does simply by rewriting the law. Next class, we're going to look at a lot of the various limits to this power. Because while we've looked at lots of ways that the Supreme Court has power, they also, in lots of cases, say, no, we're not going to touch that. That's a much more complicated set of laws. You would think that the Supreme Court would want to say, we get to do whatever we want, we're supreme. That's not the case. There are lots of areas that they are not going to engage with, and we're going to start going over that tomorrow. Not tomorrow, but next video I release. We're going to cover lots of cases to make this happen, and so rather than having you all brief all of them, I'm going to go over them all with you and allow you to brief them if you choose to. So I'm going to release them for you. We're still going to have the normal discussion board sort of stuff going up, but I'm not going to have you all brief it. Therefore, there's no official reading, but when I release the notes from my lesson, you guys will have all the references to those cases for your convenience. Some people are still having difficulty accessing OneNote. I'm going to go over that one more time with you all. Effectively, the way that OneNote is going to work is, for your convenience, I've distributed to you all of the different pages you need, but you will not see all these different things like I do. You will see your notebook, your content sections up here. You will not have a teachers only section, but if you, for example, and I'm just going to click somebody randomly, go here, you will have these tabs for you. You were supposed to create a Rodriguez versus United States thing, and I would have put notes for you. And then I have created for you the next three and distributed those to everybody. Use those that I've distributed to you. If you were somebody who already started writing stuff, I have already moved it for you. Let's see, there we go. I apologize. I didn't record the video for this portion of it. So you will not see all the other students tabs. You will just see your personal tab. And then I have created these cases for this week for you. If you're an eager achiever who's already gone through and filled out your stuff, I've copied and pasted it into this new tab. This is going to make grading a lot easier for me. So please use the tabs I've created, or the pages I've created. You are simply going to write your case briefs in here, and we'll go from there. If you haven't done so, create Rodriguez versus United States. I believe 2 or 3 of you haven't. I'm going to probably mark those as zeros tonight and You'll have to come up with a real good reason why you haven't done it if you want me to change that grade. As usual, please feel free to reach out to me if you have any questions or concerns. Canvas, cell phone, everything is available to you. Thank you all. Have a great week, and I look forward to seeing what you all say in the discussion. Have a good night.